So good afternoon, everyone. Welcome to this COVID-19 strategic considerations seminar that we're doing with IAPS. I'm Helen Tucker. I'm a partner in the education team at Stone King, and I'm joined by Stephen Ravenscroft, a partner in our charity team at Stone King. Behind the scenes, we've also got Sam, who I'm going to be asking to move the slides on for us as we go. So please bear with us in relation to that. So turning to our first slide, that's just an overview of what we're going to cover in the session. So I'm going to deal with some of the immediate issues that we've been dealing with in our day-to-day casework. So that's around some of the complaints that we've been seeing from parents arising from issues with the parent contract, fee reductions, things like that. And moving on from that, I'm going to look at some of the risks that arise as a result and some of the steps that we can take to manage those risks. Stephen will then take over and he will pick up on some of the common charity law questions that have been arising. That'll be things like serious incident reporting, looking at permanent endowment, use of premises, and then he will also look at some of the longer term considerations and some of the strategic opportunities that there may be coming out of this situation. So that's the overview. We have to set that obviously into the current context, and this slide is just a set of facts that everyone will be familiar with, so I won't run through them, but that gives us the context of where we are and what we're looking at, as obviously most schools will be in at least partial closure, and there's still quite a lot of uncertainty in terms of timing, and schools are at different positions in terms of what they're doing in relation to fees. But what I do think is coming through certainly are questions from parents arising from the positions that schools are taking. So that's the current context. And then we have, I think it's probably worth briefly overlaying that against what was the pre-COVID-19 context, where schools were already navigating a whole series of issues that we were looking at, and which I think will probably be more relevant when we come on to looking more at the strategic longer term considerations, because all of those are still in the background. They may still have some relevance for us to take into account. So, Sam, if we could go on to the first immediate issue that I wanted to pick up on, which is parental complaints. This is probably the one that we're dealing with most commonly at the moment, and this is where parents are responding to the communications that have been sent out by schools, whether that's the letters making reductions in fees or explaining the basis of the decisions that schools have been making. And stepping back from it for a moment, one of the questions we should be thinking about is whether or not those letters actually constitute formal complaints. The first thing to think about in relation to that is what your parent contract says, because parent contracts will vary in what they say about parental complaints, for example, whether it relates to matters of care, education, safety, discipline, progress of children. It's usually defined by reference to do with something to do with the child and their educational provision. But that's slightly different to what ISI define as complaints. They refer to any matter which a parent or pupil is unhappy about and where they're seeking action from the school. And the ISI commentary specifically states that if you're attempting to limit the scope of complaints in any way, you could risk breaching that standard. So it's worth having those two things in mind when you're actually thinking about whether or not you should be sitting within the complaints framework when dealing with some of the issues that parents are raising. Obviously, it will be very difficult to set up multiple formal complaints processes to deal with these communications that are coming, and that wouldn't be practical and probably isn't actually what parents want either. And particularly where you've got the main issue being the level of fees, you know, arguably that isn't really appropriate for the complaints process, but it doesn't mean to say that, strictly speaking, it isn't. So one of the things that you can do is to say, well, the head will look at the issues that relate to the remote provision, perhaps, or the education provision in some form, and trustees might respond to the issues to do with the fees, because obviously it's within their authority and their powers to set fee levels and to make decisions around the application of charitable funds. Obviously, it may not be as simple as that, because sometimes these letters are caught up in questions about the quality of the educational provision itself. So it may not be straightforward, and it may be that they can be managed by looking at the remedy that people are seeking and trying to manage that in terms of finding some sensible approach between the two. Because as I said, I don't think parents are generally speaking looking for going through a panel process either. So that those are some of the issues. There's also, I suppose, another layer in that is that there's an informal stage of the complaints process, and that can be written. So I think we can allow ourselves a little opportunity where we're responding to these concerns, even if we're trying to direct people more towards trustees than through the formal process, where we can say it's actually at the informal stage, because even the ISI commentary reflects the fact that that can be written before it actually hits the formal stage of the process. So the next bullet point says, look at the approach. So we've seen various things at different schools. Some where a group of parents have come together and they've all written one letter signed by multiple parents. We've got ones where the questions that parents are asking vary in nature, and ones where, you know, you could have 20 parents all asking similar questions but not quite the same. So there are different issues at different schools, and obviously depending on the situation there will affect how you deal with it. But there are a few things to bear in mind, because in some instances parents are comparing notes, unsurprisingly, so we have to think about whether or not we should be adopting quite a consistent approach, whilst also balancing the fact that there's a sort of PR piece around making sure it's personalised. You're actually answering the questions that are specific to the context of the individual as well. So with some schools that we've helped, we have looked at trying to create essentially a template letter that gives some of the core consistent messaging that you want to give to your parents, possibly even a Q&A answering some of the key themes and key questions, which can then be tailored and adapted to include reference to any of the very specific issues to that particular parent, which then tries to balance those different issues around consistency and sort of the precedent setting, etc., that are things to be considered when looking at that. I mean, some of the messages that we've seen are things like reminding parents that actually budgets are set on an annual basis and split then across 3 terms. The fact that trustees have the obligation to try and maintain the stability and continuity of the school. So, and whilst there are still lots of uncertainties around the future, it's quite challenging to set specific levels at the outset. So there's some sort of consistent messages that can be given, and then those will be helpful to all. Depending on the nature of the sort of strength of the complaints that are coming through from parents, there may be some that justify notifying insurers if you feel that they may become litigious. That's just something to bear in mind. We haven't seen too many of those yet, but I suspect that some may start to progress in that way. So that's something to be thinking about. And then one of the issues that I particularly wanted to pick up on was, is it force majeure? Which has become a bit of a buzzword recently, and actually some of the letters from parents actually expressly ask, is this a force majeure? Has the school declared a force majeure? And so we then have to sort of expressly tackle that, the response to that. Force majeure can sometimes be called events beyond your control, and where force majeure provisions are in your contract, they will almost always include pandemic. So you may well have provisions in the contract which could apply to this circumstance, but actually whether or not you want to expressly rely on those at this stage is actually quite a difficult balance of risk in most circumstances. And the clauses themselves vary in quite surprisingly in their extent and how they're phrased. So some, but not all, will include termination rights, by which I mean after a certain period of time from notifying the force majeure, the other party has the right to terminate without notice, perhaps without fees in lieu. So, for example, in some contracts, if you say this is a force majeure, the parent might, after 90 days, which of course in the current circumstances we don't know if it will go on for 90 days, could mean that parents can then just simply terminate with no notice at the end of the expiry of the 90-day period. Some don't include that provision, so it will vary, and some of the provisions are mutual, which means that parents may expressly have the right to declare force majeure themselves. The wording of those provisions also varies, and we have seen some instances of parents trying to declare a force majeure themselves, whether that's on the basis that the pupil can't attend the school, or whether it's on the basis that they are saying that the pandemic has either prevented or delayed them from being able to meet their obligations, i.e. to make payments. They need a bit of unpicking, and again, the clauses do vary in their nature. So some of the clauses will say if you are actually prevented, and that's different from delayed. Some of the clauses say if you're prevented in terms of all of your obligations, some say any of your obligations, and that can be on both sides again. So actually the way in which they operate and the different rights and opportunities you have and the level at which you can use those clauses does vary, both on the school side and the parent side, and they need careful reading just to be sure that you understand what your particular contract provides. I think that's, yeah, they're probably the key, and also notification provisions as well. If you are looking to rely on it, then you do need to make sure that you have notified formally if that's what the contract requires you to do. As I said, the decision about whether to actually formally confirm force majeure applies is usually a difficult balance, because, as I say, in some cases there may be the termination rights that you may be thinking about. It does provide a defence against breach of contract claims. So, for example, if a parent said the provision is inadequate in some way, then you would have a defence if you have relied on your force majeure provisions against delivering that education. There is a sort of feeling that if a school says I'm declaring force majeure, that perhaps that gives the impression that you aren't delivering your obligations, which may be an impression that may not be correct, but also that has to be borne in mind when thinking about how we're communicating what the school is delivering. Because in fact, if you have a very strong, robust provision and that's what you're telling everybody, why would you at the same time be declaring a force majeure? There is, as a slight aside to it, a possibility in some contracts of declaring a force majeure in relation to an aspect. This is quite complicated to do and also quite untested, but you could see an argument in which you might want to say that you declared a force majeure, for example, in relation to boarding provision. That may not be the case if you have reduced fees in relation to boarding or waived them entirely, but it's just something that is a possible option that you might want to explore. So, as I say, there's quite a difficult balance. A lot of schools have stayed silent on it, quite a lot taking a pragmatic view of here is the provision. Usually we have offered a reduced fee to reflect the fact it isn't exactly the same as a school provision, and to some extent where parents then pay that reduced fee, that mitigates your risk anyway, because arguably they have then accepted the basis on which that reduced provision has been provided, and they've paid that reduced fee accordingly. So there's also the argument that you're protected in that respect in any event. It's something that should be kept under review because circumstances may change, both because if, for example, it carries on, it may be that you could experience technical issues with the provision, the remote provision itself. If, for example, a number of staff get sick at any particular time and you're unable to deliver the provision, there are a range of things that are unknown, and so it's something that is sensible to keep under review. So I'm going to move on from parental complaints, Sam, and move on to the next slide. And that is where still thinking about complaints, but thinking about more financial difficulty. So where the communication that's coming from parents is actually about the fact that they are experiencing financial difficulty at the moment. We're very commonly seeing schools being faced with requests for deferring payments, instalment payments, payment holidays, etc., etc. And so, again, this is something no doubt schools are already dealing with, and I know that a lot of schools will be very familiar with the consumer credit issues, that if you give parents additional time to pay fees, that can create problems in terms of the consumer credit and financial services requirements. So if the school is not FCA authorised, you need to be very careful around agreeing any sort of delayed payment terms. This is quite a difficult balance for schools at the moment, because obviously there's issues around cash flow where, if you do allow delays in payment, and there's obviously the need, particularly at the moment, for credit control and debt collection practices to still continue as effectively as possible. But you're also mindful, no doubt, of the issues experienced by some of your parents and wanting to help wherever you can, particularly if there is an impact on the pupils. And also the consideration of trying to retain parents in the longer term, particularly where you think that the issues may be sort of short term on the parent's side. And inevitably, there is an element to which we're still managing the communication piece to the parent body and the community as a whole. And the ethos of the school and how that's being portrayed is part of every communication and how the school is managing the situation as a whole. So there is that overlay of the approach to be taken into account. As a broad principle, the position relating to effective credit control and debt recovery kind of remains the same, and that's important, as I said, anyway, from a cash flow perspective. I think the next step for schools is to think about the case-by-case basis. So looking at the situation and almost firstly delineating it into two categories. So have we got people who can't pay, or have we got people who won't pay? In the can't pay category, it may be that there's the bursary route, or if you have a hardship fund, or if you've established a hardship fund, or have those funds available to you, it may be that you can seek further information from the parents as to their financial circumstances, and explore those routes with them, which may be appropriate at this time. There are other options available, which I've put on the slide. So there are exemptions to the consumer credit provisions, which have to be managed carefully, but you can. So for example, just before the beginning of this term, if parents were previously paying termly, before those fees fell due, there was an option to allow them to pay in instalments for this term. There are certain stipulations for the number of payments within the particular time frame, so they have to be managed, but that is an option. So before the next set of fees fall due, you're able to agree within certain limits instalments. There's also obviously taking an approach of wait and see, which means that you're not agreeing a specific set of instalment payments with a parent and a different deferment or credit period, but you are acknowledging that you're not going to pursue them at this time for those fees, and that can become formalised in the forbearance letter. So that's where a parent wants written confirmation, essentially, that the school's not going to take formal action at this point in time, but it's not a formal deferment of fees as such. So as I say, that there are options. They are all slightly technical, but there are ways in which they can be navigated. Then you've got the category of parents that, in inverted commas, won't pay. And in those cases, they probably come back to the category we were talking about at the start, where we've got the communications ongoing around issues that could be categorized as complaints. So that's around trying to understand what the issues are and whether they can be resolved, whether that's through the formal process, whether that's just through standard communications with them to come to an understanding. If not, then you have a more difficult decision about whether or not you're going to be treating it as in accordance with your parent contract for non-payment. We have seen issues arise, particularly where pupils are in their sort of final years with exams. Obviously, that won't apply so much to prep schools, perhaps, but we have certainly seen parents argue that if there isn't much teaching, and why should they pay for this term? And schools grappling with whether or not they can terminate when the child needs to have their exam grades issued, and that is quite tricky. It will depend on known circumstances of the parent, what the non-payment terms say, where the issue arises from, and therefore inform the approach, because it may well be possible to simply terminate on the basis of non-payment if that is appropriate in all the circumstances. So, and we have seen circumstances where that is the way forward for those parents. So, could I have the next slide, please, Sam? Thank you. That's so we're going to look at where this takes us now in terms of risks. So, I mean, obviously we've touched on some of those risks that arise inevitably from cash flow, parental difficulties, potential recession. Lots of discussion with our boarding school clients around concerns that perhaps some of the international boarders may choose not to return to the UK in the shorter term at least. And so, you know, that's something we might turn to and look at further in terms of the longer term strategic options and opportunities. As I said before about staff, you know, it may be that staff become unwell. We need to think about that and how that can be managed, including the possibility of force majeure if necessary. But then coming back again, and at the top I've got there about the sort of issues arising from the communications with parents and whether they may turn into either complaints which require management or potentially more formal action. Now, the formal action could be, the most obvious one is breach of contract by the parents if they feel the provision has not been adequate or they feel that they haven't received what they are paying for in some way, shape or form. There could be educational negligence. There's also, if we think about pupils in particular categories, so if you've got people who had a welfare issue of some kind, you could have failure to safeguard. If you have a people that had a particular learning need or disability perhaps, and there were no particular steps taken in relation to those pupils and how the provision is differentiated for them, or you know what strategies put in place to support them, you could have Equality Act claims for failure to make reasonable adjustments, disability discrimination, that those kinds of things could arise. So, and I suppose thinking about it further, you could also have things around data sharing in the context of pupils as well. So that there are a raft of risks to manage. Sam, can we move on to risk mitigation? Thank you. And so what I've thought about is the different ways in which schools can sort of navigate those issues whilst trying to mitigate those risks. So we've touched on communications with parents and thinking about how we manage that, how we think about a consistent approach. Enhancement of the remote provision is always something which will be helpful to the school, whether that's defending the fee levels that have been set, whether that's around the provision that's been made to individual pupils. That will always be helpful. So documenting that is very important. So keeping a record of the provision that's been put in place, keeping a record of any additional pastoral care that's been given to pupils, any other support, access to counselling, for example, any support that's been given to individual pupils. So obviously that would be on their individual record, but if there have been strategies adopted to support particular pupils, then that would be helpful to record as well. All of this comes back to how you're documenting your risk. So of course, you should have your risk assessment, your overarching risk assessment with all the risks identified in it. Then you should have the strategies against those risks, which then need to be regularly monitored and updated and just adjusted. So what is important is that senior leaders are feeding into that risk management process. That will include people like your IT team, thinking about cyber risks, the suitability of the platforms that are being used for pupils, any settings that need to be adopted on those. Your data protection officers also looking at data sharing and where that's happening and how that can be managed, data security. DSLs looking at it together with pastoral leads, perhaps in terms of the individual pupils that may need care, and also overall looking at the provision from that well-being and pastoral perspective. All of those things and documenting those things through your risk process will be helpful in terms of supporting the school in terms of any potential complaints or claims that could come as a result of this. Staff training, obviously, what I mean by that is so that they understand what new arrangements are in place, so that they understand if they need to be documenting any actions that they're taking, so that they are very familiar with any revised policies. So obviously the child protection policy should have an addendum to it with any specific procedures that should apply at the current time. Everyone should be made aware of that and understand what actions they are responsible for in relation to that. So I think they are probably the main areas of risk mitigation in terms of the risks that we've identified. Overall, that it's about the consistent messaging as well with the parents and making sure that they understand and are on board as much as possible with the school's approach. That goes up as well to trustee level, because in terms of them understanding what risks are identified in relation to the school, and also keeping an overview of how those are being managed effectively. And I think this is probably a good time for me to pass over to Stephen, sort of from the trustee perspective and thinking about charity law considerations arising. So thank you.
Great, many thanks indeed, Helen, and good afternoon, everybody. So yes, I'm going to have a look at some of the charity law issues that we all ought to be thinking about at this stage, on the basis that I'm assuming that a large majority of you on the call will be charities in any event, and then we'll look at some of the strategic long-term issues, or the longer-term issues anyway. And I sort of sit here both as a partner at Stone King, but also as a governor of 2 independent schools. So sort of elements of this where I'm sort of living and breathing as we go through this process. So in terms of the charity law considerations, I think there was a lot of concern and angst, I think, in the lead up to the start of this term with regard to fees, looking at how the fees have been set for this term, and also the fees have been set for the forthcoming academic year, and the decision-making processes that trustees will have been through as part of that. And the important aspect there is ensuring that in terms of the decision that's been taken, schools generally will have the contractual right to determine the level of fees that they charge. If the decision is taken and has been communicated now before the start of this term, that the fees are going to be either reduced upfront and then potentially looked at a later stage to see if there are any further savings that have been made, or alternatively will be charged at the normal rate, and then there'll be a process undertaken at the end of the term to look and see what fees should be charged on the basis of any savings that have been made. Then, provided all of that has been communicated to parents, they are aware of that before the start of term, then it's a matter of contract law as to whether those fees are reduced, and that's for the school to determine what that level should be. Obviously, a school acting, and the governors of a school acting as charity trustees have an obligation to ensure that those fees are charged at an appropriate level, and it would not be open just to say, well, we're just not going to charge any fees at all for the next term, or that would be a fairly brave thing to do, depending on your financial circumstances. But I think provided there is a reasonable process undertaken, and you've taken into account relevant factors in terms of any cut in terms of fees being charged, then those are all relevant processes, relevant factors to take into consideration when determining the level of fees to be charged. Now, I know at the start of the COVID lockdown, there was a lot of talk about ex gratia payments and potentially having to go to the Charity Commission to seek consent to any proposed cutting fees. We've looked at this. We've also spoken to the Charity Commission's head of legal about this point to try and understand the basis here, or the basis of any concerns that may have been raised, because we couldn't really see that, provided you were following a contractual process and you weren't just voluntarily agreeing to reduce somebody's fees once they'd paid the full fees, and they'd understood that they would just be paying full fees, and you then decided just to give back funds, then provided it was all part of the process, there was dialogue before the fees were paid, then it is a matter of contract law and it's not a matter of making an ex gratia payment. So that, therefore, there's no need to go to the Charity Commission for consent for any proposed cut in fees, provided, as I say, that's done before the fees for that term fall due. Another point that's been raised by a number of clients is with regard to refunds. As I say, I think, again, if it is signposted at the start of term, so as part of the fee letter that went out before term began, that schools would be looking at costs over the course of the term and would be deciding whether or not refunds could be offered at a later stage, reflecting costs that have been saved, then I think in those circumstances, refunds can be made. But as I say, if you charge a certain level of fee and then unilaterally want to then reduce that fee level further without giving any form of commitment to parents that you do so, then that potentially puts you into the field of an ex gratia payment, and potentially would then require consent from the Charity Commission to be able to do that. So those were some of the very early points that cropped up in terms of some of the key charity law considerations. What has subsequently, things obviously move at a very fast pace at the moment, and things that have cropped up over the course of the last couple of weeks. We've identified there schools working to support the NHS or key workers, or just become more of a community resource. And I think in those cases, it is, unfortunately, although you're charities, and most of you will be charities, and you'd like just to be generous as a charity, it is very much a case of having to look at the objects for your individual school to see what they say. Most will be to advance education. Some will have to do things that are otherwise for the benefit of the community that the school serves. And it will be a case of looking at those and determining whether, for example, if you wanted to allow maybe a boarding house to be used for worker accommodation, for example, or in other ways help out with hostel for homeless people, something like that. It would be a case, I think, very much of looking at those objects and determining whether or not there's anything in those objects that would potentially permit that alternative usage to be made of the school's facilities and of the school's assets. The only other potential way of doing it is that if you were to let out the boarding house very much as a landlord and have a tenant relationship with, say, a sort of homeless charity or something, and let them make use of the boarding house, then in those circumstances it would be potentially possible to do that as a letting, and you wouldn't need to have objects that would be consistent with that. But that would be a case of looking at the detail in each and every case. The other issue that has cropped up, and we're getting a fair few queries about this at the moment, concerns permanent endowment and the use potentially of permanent endowment. So that is funds where you can spend income, but you can't spend the capital. Now, many schools just won't have permanent endowment, but some will. And some of the more established schools may well have permanent endowment. And often there can be quite a bit of capital sitting there, which you can't access. You can spend the income, but you can't spend the capital. And in those circumstances, we're finding that there are two potential ways forward. One is to say, well, we want to actually be able to spend some of our capital, so to spend some of the permanent endowment. Now, it may be that you've got a small little gift that was given, and it's less than £10,000 in capital value. And in those circumstances, the charity can resolve to spend that. It doesn't need to obtain consent to be able to spend that element of the permanent endowment. But if the capital value of the permanent endowment is in excess of £10,000 a year, or if the income from the permanent endowment is in excess of £1,000 a year, then in those circumstances, it's still possible to apply to spend the permanent endowment, but that permanent endowment would, or any expenditure would be subject to any consent that the Charity Commission any views that the Charity Commission may have. So there's a process to follow. The charity would pass a resolution to suspend the permanent endowment, and they would submit that into the Charity Commission. The Charity Commission would then consider that and would determine whether this ultimately is in the overall best interests of the charity. Permanent endowment, it's there, and once it's spent, it's spent. So I think any decision now to spend permanent endowment would need to be very carefully considered, and it's something that would need to be looked at. With my governor hat on, permanent endowment was spent back in the 1970s. We then repaid into that permanent endowment to make good the funds that had been lost. But that was quite an effort on our part to do that. So I think long and hard before using it, but equally, if you are sitting on capital assets, capital funds that could be spent, if only you had the ability to do so, then be mindful of the fact that there are powers within the Charities Act to enable you to spend permanent endowment. The other bit that we're also finding is that some of our charity clients are looking at their assets and are seeing that they've got maybe land that's held as functional permanent endowment, so it's used for the purposes of the school, but they want to borrow money for cash flow purposes. But the bank, whether it's part of the business interruption scheme, but the bank would want to take security over those assets. And in most cases, you can provide security over assets, whether they're permanently endowed or whether they're not permanently endowed. But if they are permanently endowed, you need to look at that again more carefully to see whether that's an appropriate course of action to follow, but also just to check that there are appropriate powers within whatever constitution you've got to enable that permanent endowment to be spent. So I think that's something where probably detailed legal advice would be needed if that was something that you were thinking of doing. We've got a couple of applications at the moment to the Charity Commission for consent on those aspects, and I think generally we're finding the Charity Commission responsive to particular COVID-19 based applications and concerns that have been raised. So I think if there is something that, if there is permanent endowment there that you're sitting thinking, well, I can't use it, but really would like to be able to use that, then do consider whether you might be able to use some of the powers under the Charities Act to enable the use of those funds. Okay, so next slide, and moving on to serious incident reporting. Obviously, there's nothing particularly new about serious incident reporting, and I'm sure we're all, over the course of the years, have got used to considering the various bases upon which you might need to report a serious incident. The Charity Commission rather confused things at the beginning of the lockdown by issuing revised guidance, which suggested that an issue coming out of COVID-19 should be reported as a serious incident if it had a significant impact upon your charity. So it seemed to be putting another test upon serious incident reporting and potentially requiring charities to report where there might have been an impact on income, for example, but nothing that was sort of out of the ordinary, or out of what others would have been also experiencing as part of COVID-19, or may not have had an existential threat to the operation of the charity. But the Commission has since issued confirmatory guidelines to saying that, again, it is very much back to the general tests for serious incident reporting. So if you have a series of circumstances whereby this would amount to a serious incident for your charity, then that incident should be reported to the Charity Commission in the usual way, and that's in the usual way is through the forms that are available on the Charity Commission's website. And I think probably, obviously, the one that sort of jumps out most is around loss of money or assets, and I suppose the financial strain that this may be putting upon schools at the moment. And I suppose if there were to be a significant threat to your finances, such that you were likely not to be able to continue to operate, for example, then that would amount to a serious incident in our view, and one that would need to be reported to the Charity Commission as a serious incident. But I think otherwise, if it is just your income has gone down a bit, as much as everyone else's income has gone down a bit, but you've been able to plan that so that financially it will be tough, but you think you will get through it, then that's not necessarily an incident where we would say would need to be reported to the Charity Commission as a serious incident. So that's that on serious incident reporting. Now moving on to strategic options on the next slide, Sam, if that's okay. So I suppose, again, and Helen touched on this as elements of part of the pre-existing context at the beginning of the webinar this afternoon. But there were obviously various aspects that were in existence and various threats that were in existence back at the start of the year. And none of those really have changed. They've probably gone into greater focus in certain respects. I mean, the comment that was made to me by a school the other day was they were concerned about TPS before and what to do about pensions. They were concerned about doing anything because of the impact on staff. I think probably now, and maybe a little bit cynically, but I think probably there will be enough uncertainty in the world that TPS is exactly the sort of thing that I think schools going forward should all, ought to be thinking about and ought to be looking at. Again, there are the various other pressures that we were facing before all of this started in terms of rates, in terms of affordability, and none of those issues have gone away, but I think do still very much form a relevant part of the options process that you should be going through at this stage. And I think what we're also finding is a number of queries now and a number of inquiries with regards to what the new normal might look like after COVID, and whether actually schools will be able to continue in their existing form, or whether there will need to be some form of change. Helen and I had an email through from a larger secondary school the other day, and they are very much on the front foot, thinking about options that there may be. They've got some cash and they're thinking about whether this is an opportunity now to look at working with other schools, in particular prep schools, and seeing whether there's anything that could be done there. And I think it's something that's, my view is there will be inevitably more consideration about this. There probably has been some thought about it so far. It was always a difficult conversation to have, but it may well be that the financial pressures that schools will be facing, and I think, unfortunately, prep schools probably are more towards will probably have less healthy bank balances just because of their size. I think it would inevitably mean that some of these group arrangements and potentially leading to merger will be important considerations going forward. So we've identified there on the slide, whether we have an informal structure of some sort of more formal partnership arrangement whereby we're looking to share some staff, for example, or some sort of formal grouping where we have a series of schools, but they're all part of the one charity group, might be an option, and then potentially leading to a full merger solution. I think all of those are relevant considerations, and probably not things that one would have been thinking about in the immediate post-lockdown phase. It's very much a case of designing school, what is school going to look like, dealing with parents. But I think as we now enter into this, enter into the new term and things begin to settle down a little bit in this newer sense of normal, then I think certainly it's something that governors ought to be starting to think about, and ought to be starting to look, think about what the school might look like once we get through to the other side of this. I think, and then Sam, just moving on to the next slide, if that's okay. In terms of other strategic options that we ought, or that we could be looking at, again, international schools were very much the focus before, and a way of earning vital extra funds through licensing the school's name and brand and so on and so forth to an overseas school, to an overseas operator. We are still seeing, even in the post-lockdown period, interest in this area. I think, obviously, as I'll cover off in a few moments, I think the shape and feel of the international market may well change over the course of the next few months, and it may well feel a little bit different. And I think where we're seeing that in particular is in terms of international borders, for example, deciding whether they're going to come back, or international borders who were going to join school next year, whether they will still want to do so in the light of everything that's going on. I suppose paradoxically, that does represent a bit of an opportunity in terms of if you've got parents who aren't prepared to send their children here, might they be prepared to receive an education, an English education, over in China, over in the Far East, wherever they may be, and therefore potentially more scope for international work and international growth and expansion in that way. But with every international project that we've been involved with, and we're involved with a number now, there are always issues that crop up, and there are always risks with any approach, and there can be a lot of time spent courting and dealing with international suitors, and it may not necessarily always lead to a positive outcome at the end. But I think the ones where we have seen international income come through, it's often worth quite a bit of money, and the rewards, if you get there, can be great. But that's very much that takes time. That's not a quick fix. That's it can often be years worth of negotiations before anything can start to take any particular shape. But in a more immediate sense, there are other opportunities maybe closer to home in terms of the way in which schools might operate, and looking there, as we say, at alternative income streams. Again, elements of those are no doubt under pressure as we speak, because we can't, that there aren't the school's facilities being used, the sports hall can't be used because lockdown. But nevertheless, I think coming out of this, pre-planning with regard to whether there is any further use that can be made of your existing facilities is something that's well worth bearing in mind. We've identified there trading subsidiaries as a way of, if you are getting into any form of more significant, and probably the figure there is £80,000, but anything more significant in terms of non-charitable trading, then it's definitely worth, well, it will be a requirement quite often to set up a trading subsidiary to operate that particular activity. So if anything that falls strictly outside of the wording of your objects, and those objects, as we said at the beginning, are likely to be educational. If there's anything that falls outside of there, then again, looking at the option of running that through a trading subsidiary, which also then helps to ring fence the risk, is a useful thing to do. We've also there referred to change of offer, and again, a number of schools looking at moving from single sex to co-ed. Age range change, so whether moving from prep to including pre-prep, for example, or prep moving up to include some form of secondary provision, are all things that have been looked at by schools over the course of the last few years. And again, as part of the overall considerations that schools ought to be bearing in mind at the moment, things that very much should be at the forefront of people's minds. And we've also identified a change to the cost model. Now, I suppose at the moment, fees are under pressure like they've never been under pressure before. And looking at what schools provide and what they don't provide, and the premises in which they provide or don't provide those services are, I think, all the more important and relevant. So again, I think looking just as a firm, we're now seeing that there's much less focus on our physical offices because we're able to do these talks, we're able to talk to clients and contacts remotely. Now, that's not to say that education can be done remotely in anywhere near the same sort of way. Having said that, I've got one son Zooming at the moment and one son Microsoft classrooming at the moment, and both seem to be doing quite well out of it, frankly. But nevertheless, I think there will be opportunities to look at the way in which education is provided going forward, and maybe just using some of the experiences, trying to take some of the positives out of the circumstances that we find ourselves in at the moment. So Sam, if you could just flip the slide now onto opportunities, and just building on that, you'll see the second point there is around packaging IP, so packaging intellectual property. There are ways in which we educate children, there are ways in which things are done, and whether there are particular ways in which your school provides an education, whether that is in any way, shape or form something that could be looked at as being a curriculum or a particular way of teaching that could be shared with others and could be packaged and shared with other schools as a way of providing an excellent education, potentially delivered by way of a video or delivered by way of some form of remote learning that we've developed, that we've had to build up for the course of certainly this term, where there's any opportunities there with regard to how you might be able to maximise that. And I think that's certainly something well worth looking at and considering. I think you may well have seen that there's within the maintained school space, it's either Oak or Cedar Academy. I think it's Cedar Academy which has been established, and it's an online only school that is providing education for maintained school children. And that's at one extreme. I'm not saying we should go there, but I think there are opportunities now to look at IT in a way that we may have been slightly concerned about doing, slightly reticent about doing that before. And that also applies to international students. And again, looking at how we provide school and how we operate school for international students. My son, my older one, he's got sort of students dialing in from Kenya, from China, and so on and so forth. And it is it seems to work. It seems to be a way of going forward. So again, looking at how schools might interface with international students is one way forward. And the other, and this is all about opportunities, this is about the positive uplands. And I think again, looking at those opportunities, and just to take that example I gave a few moments ago, clients of ours who are looking at merger, who are looking in a positive way, I see this as an opportunity to maybe broker those conversations, which might have been very difficult to have before with your local competitor prep schools. But it may just be that now is an opportunity to say, well, actually, we've got 10 prep schools in the local area. We think we probably need about 7 or 8. Is there some sort of way here of brokering that conversation and putting people together and seeing whether there's any way forward in terms of preserving as far as we can what we've got and what we think we will have, in terms of the ability of parents to be able to continue to pay fees, but to seize this as an opportunity and to look in a more positive way at whether this whole process represents at least a chance of having some of those conversations and seeing whether, rather than having those 10, we can have 7 or 8 who are going to be operating in a much more efficient and effective way. So that's it for our webinar for today. Thank you very much for those who have attended. We've got some questions that have been raised during the course of the webinar, and we will, I think, respond to those questions separately, and we'll get back to you as a follow-up coming out of this. But otherwise, thank you very much indeed for your time this afternoon, and we'll look forward to seeing you soon. Thank you very much. Bye-bye.